I'm Bruce Afran. I'm one of the attorneys who represented the Nader 2004 campaign in terms of its ballot access cases. And as you know, there were ballot access cases all over the country. The Nader campaign in 2000 received nearly 3 million votes in the general election. In 2004, the Nader campaign was kept off the ballot in nearly every large state, including Texas, Arizona, North Carolina, Virginia, California, Washington, Pennsylvania, and Ohio, and others, with the result that the campaign was denied at least 2 million of those 3 million votes that it had received in the 2000 election. This did not happen because of the choice of the American voter. It happened because of the actions of judges at the behest of Democratic Party officials in the various states who engaged in a concerted campaign, I think a conspiracy is probably the word Mr. Nader would use, to keep the Nader campaign off the ballot. Never in American history has a major party ever attempted to destroy its competition on the ballot through the court system. What happened in the 2004 campaign, as demonstrated in an immense degree in Pennsylvania, was a perversion of election law, designed not to protect voters' rights or to foster voter choice, but to reduce that choice through the use of law at the behest of one political party. Now, I think we can contrast this behavior in a certain way to the Republicans when they were faced with 2 successive campaigns by Ross Perot. In neither of those campaigns, despite the fact that Bill Clinton arguably was elected by Republican votes going to the Perot campaign, did the Republicans attempt to destroy a third-party campaign. Ross Perot was not challenged by the Republican Party in either the 92 or the 96 election. The Democrats in 2004 used every legal resource, not lawful, but resources in terms of legal personnel that they could muster to destroy the Nader campaign. Ralph Nader is here today in connection with the Green Party convention, and I'll introduce him in one moment to discuss in particular ballot access problems in Pennsylvania. I want to discuss for a moment, if I can, the result of the case in Pennsylvania that resulted, 1, in the destruction of the Nader campaign's ballot place, and 2, an immense judgment that is now equal to $100,000 against Ralph Nader personally, in the same manner as Mr. Romanelli spoke of a few minutes ago. Pennsylvania law required 25,697 signatures for a candidate to be on the presidential ballot in 2004. The Nader campaign submitted 51,273 signatures, twice the required amount. Now, bear in mind, this is generally done through paid circulators. It is an enormous expense, and it is immensely difficult to accomplish. The Nader campaign secured twice the required signatures. Through a series of court actions in 12 different courts in Pennsylvania, which the Democratic Party could easily finance, but the Nader campaign could not. Imagine a third-party campaign finding counsel to appear simultaneously in 12 different common plea courts in the state. Clearly, the Democrats can do that since they've got a horde of lawyers who are desperate for patronage who will volunteer, in many cases, their services in each county in the state. A third-party campaign can't do that. Pennsylvania courts were used to prevent the Nader campaign from effectively defending its position in that election. One thing Mr. Nader will speak on are reforms for Pennsylvania law, including creating a statewide nonpartisan ballot review commission. Now, in New Jersey, our neighboring state just a short distance away across the river, as Carl said, only 1,000 signatures are required. But of even more importance, there is a single statewide office where a challenge is made. A campaign need appear at one location at one time to deal with challenges, not 12 or 13 locations throughout the state, which bankrupts and destroys an independent or third-party campaign. Now remember, out of the 25,697 signatures required, the courts ultimately found only a valid number of 18,818 signatures, which according to the ruling meant the campaign fell short by about 7,000 signatures. However, of these disqualified signatures, 8,000 were disqualified not because the voter was not registered and not because the information was incorrect, but because someone else had written in the voter's address and that the handwriting differed from the signature. The address was correct in each case, the voter was a registered voter, and the voter had signed the petition. Yet because Pennsylvania law technically requires that the voter fill out every line in his own handwriting, 8,000 valid signatures were thrown out. In addition, 2,000 were thrown out because small bits of information, such as zip codes, were not included. Now, obviously, many people who fill out petitions are elderly and need help completing these documents. That's all that took place. Yet 8,000 signatures were thrown out for no other reason than the handwriting of the address was not the signatories. When you add in these 10,000 signatures, which should have been counted in any system of law, the Nader campaign had 28,818 signatures, far more than was needed to remain on the ballot in Pennsylvania. Now, in the face of this, President Judge Collins described the Nader campaign as engaging, well, the signature process in the campaign, as, quote, the most deceitful and fraudulent exercise ever perpetrated upon this court. Yet, the Supreme Court identified a total of 687 signatures out of 51,273 that were fraudulent, that were forged. Every other signature was a valid signature by a voter who put it on that paper. So the notion that the media has accepted, unfortunately, and the notion that has been placed in the court record that there was a fraudulent and deceitful process in this campaign is simply false. This campaign admirably acquired the correct number of signatures and met Pennsylvania's immensely difficult and onerous and arbitrary signature requirements. Now, just across the river, only 1,000 signatures are needed. And in New Jersey, Ralph Nader appeared on the ballot, along with several other independent candidates. In Pennsylvania, voters were not given the chance to vote for Ralph Nader. Now, one has to consider whether Pennsylvania voters have been the victim of a deceitful and fraudulent campaign. And quite frankly, the courts of Pennsylvania, with the exception of Justice Saylor, accepted this hook, line, and sinker. The result of that election was the imposition of an $80,000 penalty for costs of court transcripts and handwriting witnesses' fees that the Nader campaign was required to pay. Actually, that Ralph Nader has been ordered to pay. I'll close with this comment. This amounts to a bankrupting penalty upon any independent challenger who seeks to be on the ballot in Pennsylvania. As Mr. Romanelli said very clearly, this has a chilling effect on the willingness of people to run for office in this state. And it is not only independent candidates. Primary challengers who challenge an endorsed candidate of the political party will also be subject to this penalty in the future. And the political system in Pennsylvania needs to recognize what it has unleashed. It has unleashed a chilling monster of bankrupting penalties that will destroy political diversity in this state. In the entire jurisprudence of the 20th century, no American court has ever done what the Pennsylvania court did to Ralph Nader and Mr. Romanelli. I'm reminded of Singapore, where the government repeatedly uses libel cases to bankrupt political opponents who simply criticize government policy. In the same manner that Pennsylvania has done to these two campaigns, the Singapore courts repeatedly bankrupt their opponents with libel for merely criticizing government policy. That is where Pennsylvania is headed, unless this can change. I'll now call upon Ralph Nader to discuss this in detail and with the passion that I know he brings to this. Thank you.